Good afternoon and welcome to the Capital Forum's 6th Annual Antitrust Thought Leaders Interview Series, sponsored by KL Discovery. My name is Karina Lubell, and this afternoon I'm joined by Bruce Hoffman, who is the Acting Director of the FTC's Bureau of Competition. Bruce, thanks so much for joining us this afternoon.
Thanks for having me. I really appreciate it.
So this afternoon I'd like to talk a little bit about the FTC's approach to merger enforcement. So maybe we could start off with a discussion of remedies. Given some of the recent problems with divestiture buyers, what is the FTC's current approach to structural remedies? For example, what exactly is it that you're looking for with respect to buyers and asset packages? If we can start with that.
Sure. Let me maybe, to set the table for that a little bit, go back and talk about kind of how we got to where we are.
Sure.
So obviously remedies are really important in mergers. When you think about a merger where we have a remedy, the first thing you have to remember is that by definition in that context we have a merger that we think is illegal, right? So the merger left to its own would create an illegal effect. It would harm consumers. Mm-hmm. So the remedy is designed to make an illegal merger legal by solving the competitive problem. And it's our job to try to make sure that we actually solve the problem. Otherwise the harm that we were concerned about could still occur. So for a long time, the FTC has looked at merger remedies. You know, we've now actually had two studies, the divestiture study and the remedy study, and we also look frequently at what has happened in particular cases. And of course, we have our compliance division, which is staffed by really skilled attorneys who do this for their job. You know, every day they're looking at merger remedies. One of the things that we try to do over time at the FTC, I think this is true of antitrust enforcers generally, but it's certainly, you know, in the couple of times now that I've been at the FTC, is kind of part of the DNA of the organization, is we're always looking at our own performance and trying to evaluate, have we done the right thing? Did things work? Did they not work? What can we learn? So the current best encapsulation of all those things that we do is in the remedy study that came out last year. There's an awful lot of information in there. There's more than I could ever capture or describe today. So I would certainly suggest that anybody who wants to really get into the weeds in this, go read that in detail and look carefully at what it said. And then about some things that I and others have said subsequently to the study about what are the lessons that we've gleaned from it. So with all that sort of long, elaborate wind-up, what I would say is there are things that we learned, both things that worked and things that didn't. And I'll focus mainly on things that didn't for now.
Sure.
And sort of the biggest takeaway is we found that divestitures of packages of assets that weren't functioning business units tended to not do so well. We had a very high success rate, you know, and we used particular measures of success and failure, and I won't get into all that nitty-gritty detail, but we had a very high, close to 100% success rate, maybe 100%, I can't remember exactly, but it was extremely good for divestitures of complete business units where we were effectively divesting the equivalent of a standalone company. Mm-hmm. We had close to a 1/3 failure rate for divestitures of packages of assets that were less than a complete company.
Okay.
And so one of the things we've learned from that is to try to get something that's close to a standalone business unit when we do a divestiture. There are cases where it's not an absolute rule. I mean, there are cases where we might come to a different conclusion in a particular case. There are cases where we could be persuaded that less than a full business unit is worthwhile, but our going-in presumption is going to be we've got to have the full functioning business unit, because otherwise there's a greatly enhanced risk of failure of the divestiture, and that if that occurs, then it means that we haven't protected consumers, which is what we're trying to do.
Sure. So parties to a merger should, if they are offering anything less than a complete business unit, should have pretty good reason for why that is and why it wouldn't be anti-competitive, I suppose.
Yeah, well, not just that it wouldn't be anti-competitive, but what they have to be thinking about is, will it work? So some of the reasons that we found for the failure of these kinds of divestitures is often the assets that are in an ongoing business unit work together in ways that are not obvious to us from a competition standpoint.
I see.
There might be some kind of shared knowledge. You might have employees that work on both or work primarily on one and not so much on the other, but happen to know things that are really important to the other one. There might be synergies where you can sell the products together. The customers might prefer that, or there might be cost savings that way. There's a lot of things that can happen with assets that are not part of the competitive issue, but are really critical to the success of the assets that are the competitive issue in the market going forward.
I see.
So those are the kinds of things that are of concern. A specific example of, well, actually another example of an issue that came out of the divestiture and remedies studies, and something that I spoke about in Miami, is in the pharmaceutical context, we looked at failure rates there, and again, it's kind of a related thing. It has to do with what is the most easily divested and the most currently functional asset, something that we actually know is working. So in the pharmaceutical context, we found that divestitures in complex pharmaceutical cases, this is typically inhalants, injectables, some other kind of time release chemicals, those sorts of things. Often when pharmaceutical companies merge, what will happen is one of those products will already be on market. Typically, these are often contract manufacturers, so you'll have somebody actually making the product and selling it. The other firm will have a product similar, a competitive issue for us, but it's in development.
Sure.
In the past, we would often allow a divestiture of the product in development. We found that those failed a lot.
I see.
So now we're requiring the divestiture of the product that's actually being manufactured and not the product that's in development, because that changes the risk profile. Yeah, another way to think about this is who bears the risk? And our perspective is ultimately, and this goes back to the point that the merger is illegal. So the risk should be borne by the parties to the illegal transaction. So when we're fixing a deal and then there's going to be a risk of failure, our policy goal is to say that risk ought not be borne by the public. That risk ought to be borne by the parties. And so we've been thinking about our remedies with that in mind.
Got it. Okay. I'd like to next talk a little bit about behavioral remedies. So Assistant Attorney General Del Rahim has made a cornerstone of his tenure, sort of a skepticism towards behavioral remedies in the vertical merger context. And I'm just wondering if you could talk a little bit about the FTC's approach to behavioral remedies and vertical mergers.
Sure. So let me start by saying we haven't ruled out behavioral remedies and mergers, and I don't really understand the DOJ to have said there will never be such a thing again. But they've said they have, at the very least, an extremely strong presumption against them.
Right.
And I think substantively we are aligned with that. So when we look at merger remedies, our preference is always for the structural remedy. And there's a number of reasons for that. One is the efficacy issue that I talked about a minute ago. Structural remedies are more likely to work. You divest a business unit, you divest an entity, that's something that's more likely to succeed than the much more complex things that occur when you're doing a behavioral remedy. But also, and I think this is really critically important with behavioral versus structural remedies, in a structural remedy you change the incentives. So when you divest all the assets that are involved in the competitive problem, you also divest with that the incentive to behave anti-competitively. The firm that did the divestiture is no longer going to benefit from anti-competitive behavior, from price increases, from output restrictions. They're not going to benefit from it. So they have no incentive to harm consumers. The problem with the behavioral remedy is you don't change the incentive. All you try to do is change the ability to act on that incentive. And that's always difficult, because as people are smart, and people try to act on their incentives. So if you're in a firm and the firm has a strong incentive to raise price or reduce output, or in a vertical context, deny or limit access of a rival to an input or output that by the virtue of the merger you now have the ability to provide, if you have that incentive, you're always going to be trying to find ways to act on it. And a behavioral remedy is going to have to counteract those incentives, and that's inherently difficult. Added to that, you have the problem that behavioral remedies force us to stay involved. And again, our compliance people are excellent, but they would be the first to tell you they're not sectoral regulators, they're not company managers, there's limits on what they can do. We can appoint monitors, but they have the same kind of issues. And plus, and this is something that Assistant Attorney General Del Rahim has talked about, it injects the government on a kind of ongoing basis into the functioning of the market, which is not ideal. So the way we think about behavioral remedies and mergers is they're kind of the last option. The best option is structural. If you can't do a structural remedy, then the next question is, should we allow the merger at all? The case in which you would allow the merger with a behavioral remedy would be the case where there's some real benefit to the merger. And there's no structural remedy available, and blocking the merger would sacrifice that benefit. So you don't want to block the merger. you want to allow it through, but you have a problem you're concerned about, there's no structural fix. In that context, we would consider a behavioral remedy if we thought we could actually do it, we could actually implement it, enforce it, monitor it, carry it out, and get out in some reasonable amount of time. So those are all the things that we consider. Again, having said that, if you look at the Remedies study, it looked at, I think, 4 behavioral remedies, and it concluded that they all worked. Now, they were all very finite, very targeted, very discrete, but they worked. So it's not something we've ruled out, but it is the last option.
So that sort of leads into my next question, because I think the context in which you tend to see, or you typically see behavioral remedies, is in vertical mergers. And I'm just wondering, more generally, should we expect more rigorous enforcement when it comes to vertical mergers, given some of the issues that you've described? What do you see for the future at the FTC?
So I wouldn't say that remedy or lack of remedy equates to rigor.
Okay.
So when we have a merger that we're concerned about, and if we get a remedy, we think that's equally rigorous to blocking the merger. In both cases, we assume, and this is in part what the remedy study looked at, but we assume we're solving the competitive problem. Mm-hmm. So I would say there's not a difference between a merger remedy that's then effectuated in a consent decree and a lawsuit to block a merger, which results in the parties abandoning the merger or court order prohibiting it. In both cases, hopefully, we have solved the competitive problem.
Okay.
Having said that, in the context of vertical mergers, I spoke about this at some length in the fall. I won't reiterate that here, but it's an area that we're always looking at. We look at a lot of vertical mergers. We bring enforcement actions with a fair degree of regularity. I would not expect that to change. I do think it's true that we bring more enforcement actions in horizontal mergers for reasons that I described in my vertical merger talk. Mm-hmm. But we don't in any way, shape, or form rule out bringing enforcement actions in vertical mergers. We look at it very, very carefully. And there's work going on in the vertical context to try to provide some newer or better, more robust theories by which we could evaluate vertical mergers. And we're always trying to keep up with the scholarship and the thinking. And so that could change how we approach vertical mergers going forward.
Sure, that makes sense. I'd like to switch gears a little bit and talk somewhat about the role of efficiencies in merger analysis, both vertical and horizontal. So maybe you could talk a little bit about the FTC's approach there.
Sure. I think this is an area that gets maybe underplayed a little bit, in part because the language in the courts has often been fairly negative about efficiencies.
Right.
And so I think people need to remember that there's a lot of prosecutorial discretion before you end up in court. Mm-hmm. So we take efficiencies very, very seriously. And in part, that's why we bring fewer vertical cases, because there are more likely to be, and there more frequently are, very identifiable, cognizable, verifiable efficiencies in vertical mergers. So I think people need to be careful about assuming from the negative treatment of efficiencies in some court decisions that therefore we don't pay attention to efficiencies in exercising our prosecutorial discretion about whether to bring a case or not. We do. And we look at all the efficiencies that the mergers might provide, and we look at them very carefully and seriously. And I would say one thing that is a frequent problem that we have is I'm surprised by how often parties come before us and they don't seem to put a lot of effort into this, or they don't seem to have a good sense of what the efficiencies are. And we have had CEOs testify under oath that they haven't thought of any efficiencies, or can't come up with any, or they'll think of them later. I mean, these are almost word-for-word quotes.
Yeah.
That's not helpful to getting your merger through. If you can't come up with a good reason to do it, then, A, there's nothing for us to put on the scale in favor of the merger, and B, we start wondering, why are you doing it?
Right.
So it's an area that's often neglected. Now, I understand that there are gun jumping issues and whatnot that can make it challenging to fully articulate what the efficiencies are, but still I think people often don't put enough work into it. In terms of the efficiencies that we look at, I think there's a couple things people should bear in mind. I mean, for starters, this one should go without saying, but it's come up recently in a couple of cases. The efficiency actually has to come from the merger.
The merger specificity.
Well, this is even beyond merger specificity. Merger specificity is the merger is producing an efficiency, but that efficiency may or may not be attainable through other means, right? That's what merger specificity is. But the predicate to that is the merger is producing the efficiency. We have had some cases where the claim has been, well, because of the merger, in the future there will be some other thing that will happen which will be good. That's not an efficiency from the merger. Now, if you actually have the merger producing an efficiency, then we look at, okay, well, is there some reasonably attainable, less harmful way that you could get it? Is it merger specific? We look at whether it's verifiable. Is there good evidence to support it? Do the contemporaneous business documents support it? Does the economic theory support it? Does the data support it? Do the witnesses support it? And then is it cognizable, by which we mean, is it an efficiency that's actually likely to benefit consumers and isn't a restriction in output, a price increase? Every now and then you'll see people talk about, I've got a great efficiency. It's a revenue synergy. I'm going to get a lot more money. Now, I don't mean to say that a revenue synergy is always a price increase.
Right.
But sometimes it is, and so that's not the kind of efficiency, quote unquote, that we would credit.
Okay, yeah, that's helpful.
I do want to say one thing about out-of-market efficiencies, because
Sure.
I think this is an issue that is covered in the guidelines, but people sometimes forget. So the guidelines, and I think footnote 14, talk about out-of-market efficiencies, and what they essentially say is, look, efficiencies that are occurring in a different market are typically not part of the ultimate calculus that one would apply in determining if a merger should be permitted, because there's going to be harm here, and the fact there might be a benefit there is not something that we would typically take into account.
Yep.
Because we're not really, the agencies are not in a position to be the arbiters of who should benefit and who should not.
Right.
The exception to that is where the efficiency is, quote unquote, inextricably intertwined with the harm. And the guidelines lay out a test for that. They say, look, if the harm could be fixed without losing the efficiency, then it's not inextricably intertwined.
That makes
But
sense.
if you can't fix the harm without losing the efficiency, then it is inextricably intertwined. And that would be something we would pay some attention to.
Oh, interesting. So first of all, unfortunately, we're running out of time, but there is one more question that I would love to get your thoughts on.
Sure.
I've heard you speak about this in the past. So in recent speeches, you've made it sound that you're skeptical of the notion that a merger that increases bargaining power is necessarily anti-competitive. And I was just wondering if you could give us a few of your thoughts on the role of bargaining leverage in merger analysis. Bargaining
Sure.
leverage, bargaining power.
Well, see, I think it's really important that you put it that way, because what I'm talking about is the fact that those are two completely different things that people frequently confuse. So bargaining power has a specific economic meaning, and so does bargaining leverage, and they're not at all identical. Bargaining power refers to the fact that in a typical transaction, the Nash equilibrium is going to generate a surplus. Okay, that's a really gibberishy way to say this, but what I mean by that is when parties bargain, there's going to be some leftover benefit. And the question is, who gets what share of that benefit? Bargaining power refers to your ability to get more or less of that surplus. That has nothing to do necessarily with any reduction in competition. It could occur because you are smarter, you know things the other side doesn't, you're willing to invest more time in negotiation. So bargaining power in sort of this technical sense, when I'm thinking about Nash bargaining equilibria, refers to the ability of one firm versus the other firm to get more or less of that surplus, typically for reasons that have nothing whatsoever to do with competition. That is not an antitrust concern.
Okay.
What is an antitrust concern is a change in bargaining leverage. So bargaining leverage refers to whether the deal occurs in the first instance. And technically what it has to do with what's the relative walkaway points of the two firms engaged in the bargain. That is driven by the availability of substitutes. And so a merger that combines substitutes is going to alter bargaining leverage because it will change the walkaway point for the firm, for both firms, for the firm that loses the substitute and for the firm that internalizes the substitute. That's the classic concern of merger law, and that's what we look at. But what happens a lot is people use these terms interchangeably.
Right.
And so they don't understand that these are different things. And they'll think, well, a merger that allows one firm to bargain better because it becomes smarter, or it gets access to information it didn't previously have, or it gets resources that allow it to be more patient, for example, and to bargain for a longer period of time, that's got to be a competitive problem because it changes the bargaining power.
Right.
Not so. It's a different kind of issue. But where you're changing leverage
Natural
because you're
leverage.
eliminating a substitute, that's a problem.
Okay. Thank you for that. I think that's really helpful because I know at least I had trouble distinguishing between the two, and now understanding that it's bargaining leverage that we need to focus on in merger analysis is helpful. I think, unfortunately, that wraps it up for our interview this afternoon, but I hope to continue the conversation. But thanks so much for joining us, Bruce.
Thank you very much. It's been a pleasure.